G'day, I'm Stephen Page from Page Provan Family Fertility Lawyers, and I want to talk to you about posthumous reproduction changes in Australia. Currently, posthumous reproduction is really difficult across much of Australia. There are basically two things that we've got to look at. One is how you get to retrieve the genetic material if it's not already in storage. And the second one is how you get to use it. So retrieval is with those cases where the man or the woman, typically it's the bloke, has died too early, and there is a process to remove the sperm, and as I said, occasionally eggs, from the body. So sometimes a party knows that they're dying and they've put in place consent for posthumous use. Those cases are very much the exception. And so what we see across Australia under legislation that is named either Human Tissue Act, like it is in New South Wales and Victoria, or the Transplantation and Anatomy Act, as it is named, for example, in Queensland, or confusingly in Western Australia, the Human Tissue and Transplant Act, is the ability to retrieve sperm and eggs by a statutory process rather than having to go through a court. Because there's often this thinking that you've got to rush off to court to do it, and most of the time you don't. The irony about Western Australia is that the process is allowed there to retrieve. But I suppose there are two ironies in Western Australia. The first is that although the statutory process allows you to retrieve, time and again there's no designated officer of the hospital available to do so. And so in Western Australia you have to get court approval to be able to retrieve. And the most recent reported case of that was late last year in December 2023. And the second irony in Western Australia is you can't use, so you've got to export. And so the export typically will occur to either Queensland or the ACT. And in South Australia, Victoria and New South Wales, you can't use unless you've got the written consent of the deceased. And so what do we then see? Well, from South Australia, Victoria and New South Wales, there's export of the sperm to typically the ACT or Queensland. In Victoria, there is a process that you can get patient review panel approval, but it's just, you need to have that written consent in the first place, so it's just very, very difficult. So what I see is exporting happening. So export could happen to the Northern Territory, but the Northern Territory, the one clinic there has to, by agreement with the government, in effect comply with South Australian requirements, so it's not keen to do posthumous reproduction. And it could happen to Tasmania, but no one wants to go to Tasmania because it's small and remote. So the export has typically happened, as I said, to the ACT and Queensland. But of course this video today is about change. And so what changes are happening or are proposed to happen? And really, of those two places, the ACT and Queensland, suddenly it's going to be, well, people are going to export to Queensland only and not the ACT. Why? Because if you want to use in the ACT under the new Assisted Reproductive Technology Act 2024, ACT, you need to get either the written consent of the deceased or approval from a Supreme Court judge. So what's the alternative? Well, Queensland currently does not require approval from a Supreme Court judge. And when the consultation process was being undertaken by Queensland officials for the Assisted Reproductive Technology Bill, which has now been tabled in the State Parliament, posthumous reproduction came up, and the officials said, well, of course, we're going to have to go off to the Supreme Court and get an order, like widows do. And I piped up and said, no, they don't. That's very much the exception. Most widows go nowhere near the Supreme Court, and on my watch I've never had to go to the Supreme Court. We go through the procedure under the National Health and Medical Research Council ethical guidelines, and I explained what that was. And so the first change in Queensland is you won't be going, even though it's under the bill, which I expect will be enacted before October, there won't be a requirement to go to the Supreme Court. So if your husband has died too early and you happen to live in Western Australia or South Australia or New South Wales or Victoria or even the ACT, what are you likely to do? You'll get your retrieval and you'll export to Queensland, because there is a process to be gone through. It's going to be slightly easier than under the current ethical guidelines, but it, in essence, mirrors that. The second change in Queensland is even more meaningful to me, and it really came up a couple of years ago. A couple of years ago there was a case where a man was unconscious, he was unresponsive, he was in a coma, he was never going to get better. And his widow, or soon-to-be widow I should say, wanted to retrieve the sperm. And the treating fertility doctor came to me and said, we want to be able to retrieve sperm, because the worry is by the time he dies, his body will have deteriorated, and what might be viable sperm today, by the time he dies, won't be. It won't be able to be retrieved. And sadly, I came back to him and said, well, if you seek to retrieve today, it will be an assault, and there's no lawful way around it, not under the Guardianship and Administration Act, not under what's called the common law parens patriae jurisdiction of the Supreme Court, because both have to be in the best interests of the patient. And to remove his testicles isn't in his best interests. The hospital lawyer came to the same view. The result, there couldn't be retrieval before he died, and by the time the doctor went to retrieve, it was all too late. There wasn't viable sperm. So really bad outcome for the widow. So last year I wrote to the Queensland government and said, look, this needs to change. We need to have changes to the law to allow this retrieval where the man is unresponsive, and so we don't have a repeat of that pain. The state government's listened. The officials who are drafting this legislation have listened, and there will now be the ability in Queensland to retrieve in those circumstances. And the retrieval process in Queensland will actually be easier than it currently is under the Transplantation and Anatomy Act, because it's often a very difficult process involving 60, 80 telephone calls on our office to make it all happen. And therefore it can be done in a more orderly manner, hopefully during office hours, not at 8 p.m. on a Friday night or 5 p.m. on a Saturday, as I've seen before, and enable that sperm to be retrieved, so to enable the widow to have a decent shot at motherhood. These are exciting changes and quite significant changes, and I hope they'll be in place by October. Thank you, Stephen Page from Page, Provan Family and Fertility Lawyers.